Assalamu alaikum wa rahmatullahi wa barakatuh, and welcome back to another episode of Legal Ease, the show that converts legal jargon into legal ease. Tonight I take pleasure in hosting Naledi Makaba, an attorney. Naledi originates from the Eastern Cape and was educated in Johannesburg, completing her LLB from the University of Witwatersrand in 2012. Naledi has always been passionate about the good of the greater society and was a member of the Blood Donors Drive at Wendywood High School. Her ability to engage with people of all spheres led to a successful sporting career in softball and netball, while excelling in cultural activities such as writing, directing and starring production with a cast of her own peers. She went on to be a valued member of her residential house committee, disciplinary unit at WITS in 2012. Naledi completed her articles at Freshney Governor Attorneys, where she gained experience in all areas of law. She has a vast litigation experience and has found a passion for family law, which has resulted in a favorable outcome for her clients. In 2015, she joined the LexCorp team as a legal advisor. She's gained extensive experience in contract vetting, drafting and resolving commercial law, as well as general law problems from a range of spheres. Naledi's service delivery has been hailed as caring and honest, while assisting in a variety of languages to ensure clients explain the legal issues fluently. Naledi was called back to practice and seeks to use her network of attorneys for the best of her clients. Naledi is knowledgeable and driven. She is trusted by her clients for putting in that extra effort. Naledi runs the Johannesburg branch of Makaba and Midgley Attorneys Incorporated. The firm's name is Makaba and Midgley Attorneys, and they are based in Cape Town and Randburg. Naledi runs the Randburg office, while her business partner, Ms. Midgley, runs the Cape Town branch. The firm is in general litigation, but the firm deals with the multiple areas of law, namely criminal law, which includes bail application, after hours and in court in both the district and regional court; family law, which is tonight's topic; divorce, protection orders, maintenance, children's court matters, etc. In civil matters, she deals with evictions, spoliation, harassment orders, contractual disputes and third-party claims. Under labor law, she deals with the CCMA and bargaining council. Naledi, good evening and welcome.
Good evening, and thank you for having me.
An absolute pleasure.
It's a pleasure.
So that's a bit of a lengthy introduction, but I think well deserved.
Thank you.
Tonight's topic, we're going to be talking on family law, particularly maintenance and divorce.
Yes.
I mean, it looks very, very prevalent. According to statistics, it's like 60% of failed marriages generally in society.
Correct, yes.
And the two big areas usually is maintenance and divorce.
Correct, yes.
Now, just before we get into the maintenance angle, if one wants to divorce, how is that instituted? Like, what do you have to do?
All right. So in order to institute a divorce, one will need to approach the regional court or a high court. It depends on one's ability, financial ability, jurisdictional areas as well. You approach the courts and you issue what is called summons.
Right.
And that's how you'd normally institute a divorce.
So when you say approach, do you need an attorney, or is like self-help or DIY divorce advisable?
Not that I wouldn't personally advise, but on a financial scale, it is advisable if you cannot afford an attorney, because attorneys can be costly, and the maintenance and the divorce clerks are there to assist. So it is possible for someone to approach and do the DIY self-help divorce.
Right. Now, when we spoke about the High Court and Regional Court, obviously there's a difference in the costs of both these courts.
Yes, correct.
Obviously, the High Court is of a much higher scale than the Regional Court.
Yes, that's correct.
But is the service exactly the same? So people would think, hang on, if I go to the High Court, maybe I'm going to get a better judgment instead of sitting in front of a magistrate. Is the service the same and the result is the same?
In my experience, the reason that people have approached the High Court over the Regional Court is speed. generally high courts have less people approaching them, therefore the dates are closer and your matter will be finalized sooner. As far as the quality of judgment, I have not noticed a vast difference. I do believe either court serves well.
But in the High Court, is it true that you're going to have to need an attorney with counsel, because it's rare to find an attorney who acts as counsel?
Correct. So if you go to the High Court, you will need to pay both your attorney as well as counsel, unless you find an attorney who has rights of appearance in the High Court.
Right, and there's very few of them. Really.
There are, because you have to apply and you need a certain number of years experiences.
Now, at which court can a person institute a divorce? Now, I mean, this is a jurisdictional thing, right? And it's very important to get this right. Let's say the parties were living in Johannesburg. And they now, well, one of the parties decided she's going to go to Cape Town.
Okay.
Can she institute an action for divorce in any court, the regional court or the High Court in Cape Town?
Okay, so in terms of the Divorce Act, a person can institute a divorce in the area that they are domiciled in. I will explain domiciled a bit later, or an area that they are ordinarily resident in. And if you decide, I'm moving this month to Cape Town, and you are in Cape Town for a month before you institute your divorce, you can, as long as you can show to the court that you have been ordinarily resident in the Republic at least for a year.
For a year.
Yes.
So I think what you're saying is, for that court to enjoy jurisdiction, at least 12 months prior to that, you must be ordinarily resident.
Correct. So you can't, for example, using foreign citizens, you can't move to South Africa and 2 months later you want to divorce.
Right.
Because you need to at least be domiciled or ordinarily resident in the Republic for at least 12 months.
Okay. Now, you touched on this thing called domicile. Let's just deal with it. It's a technical term.
Correct.
It's one that lawyers understand and sometimes don't understand.
Yes.
But let's just dip into what is domicile.
Okay, so the extended term is domicile satendi et executandi. It's a mouthful, but essentially it's the address that you have chosen for yourself as your permanent address, essentially.
Right. Can that permanent address be changed?
It can be changed. It's generally used in contractual terms where you have elected for that address to be used for services of court documents, be it summons, or for a contract, if you have contracted with someone, for all documents, services to be served on that address.
But for the purposes of divorce, who do you have to notify that your domicile has changed? No one, essentially.
Yes, which is generally why in pleadings you will find that attorneys don't generally use domicile. They will say ordinarily resident, because domicilium is difficult to prove without consent, or at least in writing, providing your domicilium.
Right. Another distinguishing factor that we need to talk about is, what about a person's employment address? Can you serve summons at the work?
Because divorce needs to be served personally, if you find that the person spends most of their time at work, you can serve them using the employment address. That is sufficient, yes.
Okay. And these summons have to always be served by the sheriff of the court, right? You can't, as the attorney or the plaintiff. Can you, as the plaintiff, take the summons and go, like you see in American movies, they go and serve? Can you go and serve on your spouse? Unfortunately,
no. Our law does not allow for personal service. By that I mean for you, the plaintiff, to take it to the defendant. You have to use what is called the sheriff of the court, which comes with a cost. Even if you're doing a self-help divorce where you're trying to stem the cost, that is one cost you will not go around.
So that's a compulsory bit of the divorce proceeding. So we spoke about a court having to issue a summons, and it must have the necessary jurisdiction, and then the document is taken by the sheriff.
Correct, yes.
Now, what happens after that?
Okay, so once you have provided your document to the sheriff for service, the sheriff will then take the document and serve it on the defendant. It has to be personal service. By that I mean you cannot serve it on the mother, the sister, or anyone else, even a boss at work. It has to be personally received by that person for a divorce. For other matters, it can be served on someone else, but a divorce, it has to be personal service. Once service has been effected, the sheriff will then return what is called a return of service, and that will need to be returned to the court as proof of service.
Okay. Now, what happens if you can't find your spouse for personal service, right? Let's say now the spouse disappeared and is hiding because he doesn't want to, or he or she doesn't want to be paying maintenance, and they hope that they can't be detected. What can you do to get the sheriff, or what processes can you employ to make sure that the court is satisfied that the summons was served?
All right. In that situation, then there is a remedy called substituted service. Now, before you can affect substituted service, you need to make a court application. It's a separate court application seeking the right to serve on using another method. Accepted methods are by email. Believe it or not, by Facebook. You can serve someone now on Facebook. And you can serve on the newspaper. So if you know which area the person resides in, but you're not sure of the house address, then you can serve it in a local newspaper in the area that he lives in.
Okay. What if there's a foreign spouse, right? And you want to serve on him, but all you have is an address. So we're really talking about pre-divorce proceedings, which means that you have to ask the court for permission to use another way of service, because we're saying we're digressing from the rule of personal service.
Yes.
So we're saying to the court, look, I want to serve on this man. As you've just explained, there's newspapers, there's Facebook, which is quite interesting. And now we have the situation where all we have is an address. What do we do?
All right. When you are serving someone internationally, you can still ask for substituted service by email, or you can use a process that's called edictile citation. Now, edictile citation is when you're asking to serve through the embassy. It is an extended long process where you first have to get the documents. You get the court order allowing you to serve through the embassy. You get those documents, you send them to our embassy in South Africa. That will send it to the South African embassy in that country. That will then send the sheriff in that country to serve the person, if you have the address. If you don't have an address, then you use an email address.
So it sounds like a pretty long, complicated, and I guess expensive process, right?
To an extent, it's costly because it's a high court application to get edictile citation if your case is in the high court.
But then you have to pay for the sheriff in that foreign country. You have to pay his costs.
Correct, yes.
Yeah, so in the event, but both those services can be effected locally as well. If, again, you don't know where the person is, like you don't have a physical address,
all right,
you can use substituted services. And if you know what the address is, you can sue by edictal citation.
If it's local,
yes,
then you generally will not use edictal citation. If it is local, you then will use the normal sheriff because you have that address. Even if your spouse is in somewhere in Mpumalanga and you are in Cape Town, you still will use a sheriff because there's a sheriff in that area.
Yes. Now, who may institute an action in divorce? I mean, is it based on, let's say, fault theory, right? Now, traditionally, the party that was not at fault, would institute an action.
All right.
That stopped a few years ago. So the guilty party was the one that couldn't bring the action.
Yes.
So does it matter these days? I mean, who institutes?
Not at all. Any parties to the marriage can institute a divorce. We don't use the at fault or the guilty party method or rule anymore. It's whoever party to the divorce who wants the divorce to end can institute the divorce.
Okay.
I mean, you'll generally find that the guilty spouse would sometimes institute the divorce.
Yeah, and there's nothing wrong with that. I mean, it doesn't mean that if you're innocent or guilty, you can't be the plaintiff. That's the fact of it. Because
exactly.
Our law respects divorce on demand. That's what it really is.
Correct, yes. So there's no punishing someone for doing something wrong by forcing them to stay in the marriage or waiting for the other spouse to institute the divorce.
Absolutely. Okay, time to take a short break. Please stay tuned and join us after the break. And remember, the lines will be open and you can join the conversation. Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome back to Legal Ease, the show that converts legal jargon into legal ease. Tonight, I'm joined by Naledi, an extremely competent attorney and somebody who specializes especially in the area of family law, particularly maintenance and divorce. A reminder that the lines are open and you're welcome to join in and ask the necessary questions or make a contribution. Naledi, we were speaking about what happens when we don't have an address for the defendant, and we've explained the various methods.
Yes.
of edictal citation, alternatively substituted services,
Yes.
right? Edictal citation is a Latin term, obviously, but it means enlisting the help of the court to issue or to give you permission to use our embassy in a foreign land and get the sheriff to go and serve on that person.
Yes, that is correct.
All right. Substituted services is where we don't have an address and you say to the court, look, I can't find the person, I don't know the next of kin, can I use Facebook, which is quite interesting. So, Naledi, we have a call. Caller, please go ahead. Caller?
Good evening, how are you?
Good evening, well, thanks. And you?
Great, thanks. I would love to remain anonymous for now.
Yes.
I've got two questions that I just need to be answered
Sure.
by the competent attorney that's sitting right next to you.
Please go ahead.
The first question is lobola in terms of customary marriage or something like that, regarded as concluded marriage. And the second question is, if we are separating with my partner after paying only lobola, and then I've been prepared from day one to provide for the kids, and now due to quarrels, then she decides, you know what, perhaps you need to use maintenance as a punishment towards me. And can she go that route, whereas I do have a proof, or I've demonstrated all along that I am prepared and I'm able to provide for the little ones that cannot provide for themselves. The reason why I'm raising this question is there was this kind of quarrel, then we had to take it to the court, but prior to that, there was a family advocate intervention that I applied for. Then now, during the process, we ended up that there's no need for maintenance as well. But now I believe, because, you know, I'm of opinion that there's a kind of conspiracy there, you know, when we work in the same area, I'm from the village, blah, 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 those kind of stories. But now my question here is, can she really apply for it, whereas I've been providing and I'm continuing to, but she denies or deprives me in access, you know, just to punish me temporarily? Those are my two questions.
Thank you for the call. Quite a interesting number. There's actually 3 questions there.
All right.
So you spoke of lobola.
Yes.
Then he spoke about maintenance and whether it's adequate, and third is access.
Access to the minor child. Okay. All right. So firstly, as far as lobola is concerned, lobola on its own does not qualify as a marriage. In order for your customary marriage to qualify or to be recognized in terms of the customary laws, Marriages Act, yes, you need to not even pay the lobola, but you need to show that the lobola negotiations were held. You need to prove that there was a celebration between the two families. You know, traditionally umombeso, where you are exchanging gifts between the two families.
But it also depends on the tribal custom.
On the tribal customs of the families.
Couple, yeah.
Yes. So you don't even need to actually pay the lobola amount before the marriage can qualify. But lobola on its own does not necessarily mean that the marriage has been concluded.
Right. So what you're saying is payment of lobola is not sufficient to constitute a marriage.
Yes.
A marriage has to be registered in terms of the Customary Marriages Act.
That's correct, yes.
Registered where?
You register it at Home Affairs, where you go and register and show that you have entered into a
right.
marriage.
And the extraneous evidence apart from the payment is?
So you must show proof of the lobola negotiations. That generally comes in the form of a letter that the husband or the future husband's uncles would have sent to the family of the bride.
Okay.
To now request the lobola negotiations to take place. And then after that, then we will look at the ceremony celebrating the conclusion of the lobola negotiations.
Okay, so what happens when there's no letter or there's no evidence except the word of the parties?
There is then another requirement on its own, that there must be proof from the family members, because there may not be actual evidence. It may have been destroyed, or the claiming party may not have that evidence in their control. So you may then get evidence from other people who attended the celebrations or even the negotiations, who will come and testify to the court by form of affidavit or viva voce evidence.
Now, I've come across in the field of immigration law where the spouse is single when he comes to the country, or she comes, and she enters into a lobola arrangement. So there's no party going from his side, I understand what you're saying. There seems to be a hierarchy of respect.
Yes.
And the elders, negotiate
amongst
this thing.
themselves, yes.
Yes. It's very similar to Islamic law, where the bride's consent is taken by members of the family, and then it's announced openly that there was such a consent and there were witnesses and they would sign that
Yes.
she gave it. But in the absence of any of that, my question really is a verbal lobola sufficient?
Verbal in what sense?
So you gave the lobola as a gift, right?
Okay.
Now the verbal negotiations, is that sufficient for offer and acceptance of the marriage?
If that is your only proof that you attended the lobola negotiations, the
Should
court will
suffice.
looks at every matter on a per circumstance basis.
Right.
So if the circumstances of that case allows for the court to make the ruling that there was a valid marriage, then the court would find that there was.
His next question was maintenance. It appears that he's saying he's paying maintenance. Either the wife is saying it's not sufficient, he says it's sufficient, and he mentioned a family advocate. So what's our answer there?
Am I to assume that this is spousal maintenance or children's maintenance?
I think it's for the children.
For the
he was
children.
saying, yes.
I mean, when it comes to the maintenance of the children, that the amount, if they cannot agree, needs to be decided by a competent court, be it the maintenance court or family court, or in the divorce itself.
Right.
Yes.
He mentioned the family advocate, which I believe now will deal with the access.
The family advocate would hold an inquiry regarding perhaps even the maintenance. They do include maintenance. If it is in contestation, they then also look at access to the minor children, yes.
All right. Let's just deal with maintenance while we're on it. If you have a claim for maintenance, who goes where? What do you do to get to the first step that you want maintenance?
Okay, so the party that has control of the children or that the children live with will need to take the maintenance application to the court in the area that the children live in. So the court that has jurisdiction will be the court that the children live in. If, say, for example, the children stay with their grandmother in, let's say, in Tata in the Eastern Cape, but the mother lives in Joburg and the father lives in Cape Town, it will be the grandmother who lives with the children who will take the maintenance application to the court in Umtata.
So in this case, there's an exception because there are children and maintenance is required. The court where they reside has jurisdiction.
That's correct. It's not where the mother or where the father is, because we are looking now at the children. So we follow the children.
All right. Now, what is the process? Now, is there a maintenance court separate from the family court, from the regional court? Is there a maintenance officer in a court? How and how do you access him? Do you just pitch up, or do you make an appointment, or how does it work?
Okay, so there is a maintenance court generally in if there's in that area there's what is called the family court that will generally deal with matters, protection orders, divorces, maintenances. You will find a specific maintenance court in that court, like in Johannesburg, in the central, what used to be the Central Divorce Court, there's a floor specifically for maintenance. You will make your application, so you go and you fill out the forms and you submit your application to the maintenance officer. Now, a maintenance officer is a legally qualified person, and that's where you meet the maintenance officer. And now, when the application has been made and it needs to now proceed to be heard before the maintenance officer, a date will be provided to the person, and the other party will then be served again by sheriff or by police officers to bring the person to the maintenance inquiry.
Okay, so that's a big difference. In fact, the police SAPS seems to have the power now to go and serve the maintenance inquiry onto the respondent.
That's correct, yes.
Right. Now, when you're sitting with the maintenance officer, what are you supposed to be saying? Like, what documents must you have? Can you just say, I want 10,000 rands a month?
No, unfortunately not.
Yes.
So when you are in the maintenance inquiry, that's what it is called, you need to tell the court or the maintenance officer what it is that you're asking for. And you can't just ask for an arbitrary amount of money. You need to say, the child costs me this much. And as the father or the mother of the child, whoever the other party is, you need to contribute 50% of the child's expenses. The maintenance officer will then need proof of the child's expenses, school fees, transport, books, extramural activities, clothing, food, everything. They need proof of that. And then they will need also proof of income from both parties.
All right. Time for an ad break. Please stay tuned and join us after the break. Remember, the lines are open and you can join the conversation. Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome back to Legal Ease, the show that converts legal jargon into legal ease. Tonight gives us great pleasure to host Naledi, an expert in the area of family law and divorce. We have a caller on the line. Please go ahead, caller.
Hello, how are you?
Well, thank you.
I'm very well. I've got a problem. I've been married for more than 11 years now. I don't even know the person I'm married to. I can't find him. We got married when we were young like that. So now I have met him. I didn't find him. And then I have got these lawyers, all these government lawyers, all of them, they say they can't help me. And now my problem is, I have to apply my ID now, my other ID, card ID. When I go to Home Office, I can't apply my ID because of that. So I don't know what to do again.
Okay, ma'am, the line is not very clear. Let me just understand your question. You were married 11 years ago. Your partner has disappeared. You want to go to Home Affairs and
apply for my ID book.
Apply for an ID book, yes?
Yes. Now they say they want that person's passport, and they don't know if I don't have it. It's like more than 10 years.
They want your spouse's passport.
Yes.
Is he a foreigner?
Yes, he's a foreigner, Nigerian.
He's Nigerian.
Yes.
Naledi?
I don't understand why they are requesting the passport in the first place, because as a person, you should be able to have access to an ID if you are applying for your ID book. I don't understand what the purpose is of Home Affairs requesting the spouse's passport. What does it have anything to do with her ID? Okay.
So generally when you go in, the department wants to check and recheck the status of the foreign spouse.
Okay.
So
yeah, the thing I have to know the passport, the expiring passport, and I think that this person is in more than 10 years. I see him in with my own eyes. To say I have to go to court and divorce him first before I apply for my ID. So now I can't get my ID. That's my problem.
Right, I understand. You can't get an ID because the Department of Home Affairs says you are not living with the spouse, you must have him divorced.
Yes.
All right, but when last did you see this spouse?
I think it's more than 10 years ago.
10 years ago?
Yes.
Well, you can employ the methods that we spoke about, which is to serve a summons for divorce on the defendant via substituted services, and if he's abroad, edictal citation. So if you don't...
The problem is that I don't know whether he's still alive or abroad or in Facebook. I can't find him.
Okay, if you want to determine his status, alive or not, I suggest that you can approach the Nigerian High Commission. They will tell you where the national is and what has happened to him. And if you can't, then you can approach the High Court or the Regional Court for substituted services, which is what Naledi spoke about. But we're just going to recover that, Naledi. Spouse is missing. You can't find him. It's affecting your life. You want to end the marriage.
All right. So does the caller know which country he's in? Is he back in Nigeria, or could he be anywhere?
Could be anywhere.
Well, in that case, even substituted service, unless you have an email address, sometimes that helps. If you have an email address, then you can use substituted service and serve by email. But if you have absolutely no way of contacting that person, like you say, contact the country of origin, try to trace that person, perhaps even employ the services of what is known as a tracer. Try and trace this person.
But the Department of Home Affairs maintains a system called Movement Control Register. They will tell you when this person exited the borders. It is there. You remember the debacle on whether Grace Mugabe came or left or didn't. It was not captured on the Movement Control Register. So it was another head of state, but there was all of these things. Anyway, the point is, the Department of Home Affairs who say to you, you must go and do all of that, you must ask them, well, please tell me, when did this person leave the country? Has he left the country? Hasn't he left the country? That way you'll have facts on which to approach the court and say, look, I think he's gone back to Nigeria. He lives in Abuja. He reads the Star newspaper in Abuja. These are the things you have to say to the court, right?
That's correct.
Okay. And then you have to say it's more likely that he will get this summons if he reads this newspaper advert. It's really an advert in the newspaper.
It's an advert in the newspaper, and you then have to provide proof of that advert to the court to show that you did put it out. The best thing to do is to put it in more than one newspaper in that area. You know, perhaps there's a Star, there's the Citizen. You don't know which one he could be reading, but if you put it in more than one, perhaps someone who knows him could alert him of it.
Well, I think that the idea is that the court must be satisfied that you did try and bring the divorce summons to his attention.
That's correct.
I hope that answers your question. And if you have more difficulties, you can take Naledi's information down at the end and you can contact her for further help. So Naledi, we were speaking about access now. Remember the first caller spoke about, or the second caller spoke about access.
Correct.
There's a misconception that if you pay maintenance, you must have access. And there's a misconception if you don't pay maintenance, you don't have access.
That's true. And people need to realize that those are two different spheres of rights and responsibilities concerning a child. Access to a child is a right, where maintenance to the maintenance for the child is a responsibility. So although you are not paying maintenance, the mother does not have the right to deprive you of access to the child. Likewise, if you are not paying, or if you don't have access to the child, it does not mean that you refuse to pay maintenance for the child. Those are two separate spheres, and actually you approach the court on separate applications for those.
Now, pending the divorce, right, many people don't understand what a Rule 43 application is, which we will talk about shortly. I see there was a clip now, and it kind of indicates whose property is this. Now, usually property is all the movables and immovables assets.
Correct.
How is that determined in the split?
Okay, so firstly, the court will look at the type of marriage, the marital regime as they are known, where the spouse is married in community of property or out of community of property, and if it is out of community, was it with or without accrual? Then the court will try and follow that. If it is in community of property, generally it's a 50-50 split, unless one party then brings in their summons or in the counterclaim, whichever applies, asks the court for forfeiture. So they ask that the court finds that the other party has forfeited all patrimonial benefits to the marriage. That means all assets from the marriage, all including money, including houses, cars, everything from the marriage.
But what does forfeiture mean? I mean, let's just break that down. Forfeiture, why would you ask for forfeiture? What would be so compelling for the court to grant forfeiture? All
right. So the court has tried to move away from the whole guilty party idea. Right. But generally, looking at it, it is the guilty party. So you will ask for forfeiture if you can prove to the court that this other spouse did not contribute to the marriage. You will look at the duration of the marriage. If you're married for 6 months in community of property and this person is now trying to claim your money that you have, accumulated over years, generally the court, I would think, would grant forfeiture. So they look at the duration of the marriage. They will look at the fault of the other party. To an extent, they will look at fault as well. Was there abuse? Domestic violence, financial abuse even. So they look at those circumstances to establish or to determine whether that other party should in fact forfeit all the rights or the patrimonial benefits of the marriage.
All right. Now, what if there was a misunderstanding about the marital regime? For example, you don't know the laws of South Africa, right? And usually when you appear in front of a marriage officer, by default, your marriage is in community, right?
That's
that
correct.
means each party owns everything half, and each party shares the losses in half.
That's correct.
Okay? It's a mixing. Now, let's say you never knew what you were signing, and a document was placed in front of you. Yes, you're educated and you understand English, etc. Yeah. But you don't understand the importance of what you are signing. And you sign this document that says, out of community. So what is yours, what is mine is mine.
That's good.
And then you now go through a divorce. Would the court have sympathy with you and say, but hang on, why should you be deprived of the benefits of a marriage in community because you didn't know. I know there's the law of caveat subscriptor, let the signer beware, the court will go into all of that. But if you were really a stranger and you were made to sign some documents, especially if it was not in front of a notary public. Remember, that contract has to be signed in person in front of the notary public. And if this document was signed and then taken to the notary public, would that destroy the claim that this is a marriage out of community?
Well, by the nature of antenuptial contracts, which would put the marriage out of community of property, they need to be signed in front of a notary public. If it is not, then it's an irregular contract, and that contract, upon a court application, could actually be set aside.
Yeah.
But in the absence of that, you can bring an application to court to ask that they declare that other spouse's property or part thereof yours. So they transfer part of that by virtue of, you have to prove quite a number of requirements before you get the court to do that. Again, the court will look at the duration of the marriage. The court will look at, again, they'll look to an extent fault.
Yeah.
They will look at contribution. Did you contribute to that person's increase in estate, whether it's actually by saving the money or actually paying into an asset of theirs. So there are such circumstances where the court would declare that parts of that person's estate can be transferred to the other spouse. Remember,
part of the savings that we talk about is really a couple that married together and one couple stayed at home and contributed to their household by virtue of her labor. Looking after the children, cooking the meals, looking after the household, etc. The court said that was a contribution, that you couldn't just put a monetary value, but there was a contribution. So they might say, well, you aided the growth of the spouse's estate by 40 to 60 or whatever percentage they put.
Yes, that's correct.
But I think most people are scared of actually going through this whole exercise unless it's worth a lot of money.
People generally are afraid because, firstly, they don't know that they can bring this application to court. And secondly, again, they're worried about the financial implication of bringing this application to court. But people should know that there is that remedy for them in situations where the one party's estate grew while your estate stagnant by your contribution, in a sense.
In the household.
Yes.
Yeah. Well, time for another ad break. Please stay tuned and join us after the break. Assalamu alaikum rahmatullahi wa barakatuh. You're tuned to Legal Ease, the show that converts legal jargon into legal ease. Tonight I'm joined by the extremely talented Naledi, an attorney with immense experience in the area of maintenance and divorce and family law. Naledi, before we proceed, and seeing that we're in the last quarter of the show, what are your contact details for people to contact you?
All right. So if you would like to contact our officers, you can either call myself on 061 246 7729. I'll repeat, 061 246 7729. Alternatively, you can email on Naledi, that's spelled NALEDI, at mmalegal.co.za.
Okay, thank you for that. Now, Naledi, we've spoken about the property of the divorced couple and how it is split. Very, very important. Regarding children, what arrangements generally are made? All right.
So generally, the court is not a fan or does not like splitting the children. They like to keep the children together. So, and also they don't like to disrupt the children, whether it's schooling or if they're young, moving them between the parents too often. So generally, what the court will accept is access where one parent has primary residence, so the children stay with that parent. The other parent will then have contact. That is, that parent will be able to see the children on weekends, alternative weekends, school holidays. They will generally alternate Christmas between the parents. You can allow reasonable telephone communication. By reasonable, the court will mean you cannot expect to call a 6-year-old, for example, at 9:30 at night because generally they're sleeping. You can't also call and demand to speak to them during the day when they're at school. They will also allow that the children have some access to the parent or contact with the other parent on holidays, on Mother's Day, Father's Day, whichever applies.
Religious holidays as well, yeah.
Yes.
And tell me, with access, right, is it hard and fast? I mean, can it not be structured in a way that is least disruptive to the child. Now I'm talking about where there's two parents that enjoy co-parenting responsibilities and the primary residence is split between, it's 3 days here, 4 days. I see the courts are leaning more and more towards saying that this child must not become the victim of the parents' troubles.
That's correct. So you will find that there are parents who will say 3 days with this parent and then 3 days with that. I mean, generally, they also look at the parents' circumstances. I mean, the hard and fast rule is the best interest of the child is paramount. Whenever children are involved, that is the saying. You do not deviate from that saying. However, the court will then also take into consideration the parents. For example, police officers, nurses, they work the 4 days on, 4 days off shift.
Yes.
Now, the court will not come and force the parents to take a week split and a weekend split when it does not make sense for the parties, because then you'll find that children are left with nannies when they could be with a parent. So if the parents agree that when I am off, I have the children, when I'm on, you have the children, the court would allow that as well.
But generally, the relationship between the parents is quite strained. Is there an arbiter? Is there a third party like the Family Advocate's Office who really is the one that the court will look to? So that, people get very emotional about everything, and then when they go to court, they find, but the judge didn't even look at that. Because the judge is not going to descend into the arena of the dispute. He's going to call an expert, like the Family Advocate, which is a neutral party.
That's correct.
So the Family Advocate is critical in the area of access.
That's correct. And in fact, the Family Advocate will also hold an inquiry, and they will do site visits. They'll go to the families, the mother's house, the father's house, and they will go and check that reasonable arrangements have been made for the children as well.
But the Family Advocate doesn't himself do that, right? Or herself. I mean, they employ social workers, private psychologists, etc.
It's generally, in the public sphere, it will be the social worker that will go and do the home visits. They will do the interviews with the children, with the parties.
And if you can't wait, I mean, can you employ your own social worker? Can you have your own reports put to the Family Advocate?
Because, I mean, I'm sure you can bring those reports, but the social worker has to satisfy himself or herself that these are correct. I mean, you can go pay a friend to give these reports for you, but the social worker or the Family Advocate has to satisfy him or herself that this is correct and this is in the best interest of the child.
Right, and it will include having an interview with the child, right?
That's correct, yes.
Yes.
I mean, also that will depend on the age of the child. Obviously, the social workers know how to interact with younger children, but that will include interviewing the child. And I mean, a child will say, I want to stay with mommy because mommy gives me sweets. The social worker will know how much weight to give to the child based on the age and, the understanding of the child at that age.
There's also a myth that children are manipulated by one or other parent. How true is that? And can that be evident when the Family Advocate has this interview through the social workers?
It's as much as a myth as it is a reality, because parents unfortunately always throw the children in the middle and they make the children the tools by which to hurt the other person. However, like before, the social worker will know how much weight to give to the child. They will see that. And unfortunately, children are not good at lying. They will come, at some stage, they will expose themselves that, daddy said I must say this, or mommy said I must say this.
So the social worker is quite capable of getting to what is the best interest of the child. Yes,
and the social worker will then give a report to the Family Advocate, who will then make a recommendation. It's only a recommendation. It is not that is hard and fast. It's still, at the end of the day, the court that must make a decision.
Okay. Very important there. The court is guided by the Family Advocate's report. The Family Advocate's report is dependent upon the social worker's report.
That's correct.
But the court being the upper guardian of all minor children, that means it can overrule the parents and the Family Advocate and everyone else. But it's rare to find that the judge would descend into that, because there's just so many cases. I mean, how does he decide which party is saying what? Unless you can bring something to the judge's attention. For example, one of the spouses one of the parents are on drugs or suicidal or something really serious.
In that situation or in those circumstances, you would then be applying for sole guardianship of the children, to remove them from that dangerous situation. Or you could be asking the court to grant only supervised visit, which means that that parent cannot see the children without you or someone you have appointed supervising the visits. So they can never be left alone with the children. Situations like that do not allow sleepovers at the non-custodian parents' residence.
Right.
Yes.
Now, we touched on something very, very briefly. Maybe we just need a few minutes just to deal with this. The Rule 43 application, right? This is an interim arrangement between the parties pending finalization of the divorce.
Correct, yes.
But it only doesn't apply to a divorce in the end. It could apply to an interim arrangement between life partners, for example. People
That's
that are not married but are living together and they have a child.
Correct. Okay, but we need to ensure that we don't suggest that there's a common myth, or there's this common knowledge of what is known as a common law wife or a common law husband.
Okay,
that does not exist.
Yeah, I think we need to just say that.
Yes,
yeah.
that does not exist. There is no such thing as a common law wife or common law husband. If you live together, you need to somehow formalize your relationship. You can sign, you can get married. If you don't want to get married, you can sign.
Yeah, there's a thing called a life partner agreement, and you go in front of a notary public, and it takes the form of an antenuptial contract. So you say that who the parties are, what their contributions are, how many years they're together, and it says very clearly you're not liable for each other's debts, etc.
Exactly, yes.
Now, it's not terminated by a divorce, it is terminated by, it's a contract.
It's a
so
contract.
It's terminated by one party giving notice
Just
to the other. Listen, our life partnership is over.
That's correct. So it doesn't matter that you've been living with a man or a woman for 5 or 20 years. That does not automatically fall into a marriage. And I mean, I'll have a lot of people approaching me saying, I'm a common law wife.
Yes.
There's no such thing. And I have to tell them, there is no such. Perhaps if you have contributed to the other person's estate, again, by contribution or by saving them a contribution, then you can claim, but that again is a contractual claim more than it is a marriage claim.
Excellent. Well, we haven't had the time to complete each and every question that we've had. I mean, there's things like spousal maintenance, who can claim and when can a spouse claim, who pays for the child's maintenance and how is that calculated. For example, Naledi did speak about maintenance being split between the parties and based on need and ability, but sometimes you have disparities. You have the parties or the children that were used to a millionaire lifestyle, and the next day they find themselves in a little flat with one of the partners, and that's a big drastic change.
It is.
And then the mother has to say, no, I want to still maintain them at music school and at private lessons, and there's a whole...
And the court will take that into account. Yes.
Right. Unfortunately, we've run out of time, a very interesting topic. Just once more for Naledi to put out her details for you that want to contact her, and we hope that you've taken benefit from tonight's show. Naledi, if you just repeat your details, please.
All right. So if you'd like to contact our offices, you can call on 061-246-7729. Alternatively, email me on Naledi, NALEDI, @mmalegal.co.za.
Well, thank you very much, Naledi, for taking the time and the trouble. An excellent presentation.
Thank you for having me. It was a pleasure.
It's our pleasure. Thank you very much for joining us and for your calls and contributions. And stay tuned next week at the same time for another episode of Legal Ease. Assalamu alaikum wa rahmatullahi wa barakatuh.